At DSW, we ask the important questions, like, what shoes are you going to wear? Whether you're prepping for wedding season, festival season, or just planning the ultimate vacay, the right shoes can make or break an RSVP. So own the moment. You've got big plans, and we've got just the shoes. At the perfect price, of course. Get ready to get ready with Designer Shoe Warehouse. Head to your DSW store or dsw.com today and let us surprise you.
Welcome back to Come Back with a Warrant podcast. I'm Brandon Dinetz.
And I'm Monica Ishak. Before we kickstart this week's episode, this is your reminder that this podcast is not legal advice. It's real, unfiltered, and for entertainment purposes only. If you need to speak with a lawyer, call one. Or better yet, call us.
So welcome back. Today we're going to be talking about diversion, plea deals, and the case that follows you even when you think it should be gone. And what we mean by that is when the case at the end, if a case is dismissed and you have never had a criminal history before, you have the option of getting it expunged or sealed. But before we get to that, you still have the criminal case that has to get dealt with. And one of the ways that criminal cases get dealt with is through what's called diversion. Now, diversion means that the state attorney's office decides that they will put a pause on the prosecution if the person enters into some sort of program, and by virtue of entering into that program, the case will either be dismissed entirely or the original charges that someone was arrested on and charged with will be reduced to something else. But ultimately, diversion is generally putting someone in a much better position than they would be if they were fully prosecuted under the charges that they were brought in on, right?
Yeah. I mean, it's really kind of what we see as a break sometimes, considering the evidence.
A lot of times it is the win getting diversion. So let's go over a few examples that that we see commonly and kind of go from there with diversion. So one of the biggest examples in Palm Beach County is called a deferred prosecution agreement. So what that means, generally speaking, on a less serious felony or a misdemeanor case, if someone does not have a criminal record, the prosecutor has the discretion to offer them something called a deferred prosecution agreement, or a DPA. And what that DPA is just an agreement between the parties that if someone completes a list of conditions, the state agrees they will pause the prosecution and ultimately dismiss the case by entering what's called a null pros. And that will end the case, drop the charges, and really just close the case out. That would give someone an opportunity to then get the case taken off of their record, like I said, if they've never had anything before. The types of classes and programs that are usually included in a deferred prosecution agreement are things like community service, maybe a theft course, maybe anger management, usually a small fine to the clerk's office called the cost of prosecution. And the combination of these conditions, which are set out by the prosecutor, once a person completes that, the state then dismisses the case.
Yeah. So I guess the benefit really to a diversion is to get the outcome that you want that could ultimately allow you to get to a place where this is potentially off your record or just dismissed. And then the other benefit is that you don't have to really carry the weight of a risk of a trial to get to that outcome, because going to trial is the alternative to whatever the state is offering. And if they're offering a diversion, they're offering you a way to get a guaranteed dismissal if you do your part.
Especially with this type, with the DPA, with the deferred prosecution agreement, because in addition to the ultimate goal of getting a dismissal, which is a win, with a deferred prosecution agreement, there's no admission of guilt. Yeah. There is not even a necessity that the defendant or the client signs this paperwork. And it's just an agreement between the state and the defense. It's not bringing the court into it. It's not bringing a jury into it. It's basically the prosecutors are weighing the strength of the case, the severity of the case, and the person's criminal record, and making a decision that, okay, this is not something that we need to, take to trial. We're not looking to get someone in jail for this. They have no criminal record. let's give them this, really giving them another shot.
Yeah.
And once people are able to get that DPA and get that dismissal, oftentimes you don't see them back again. They're not usually recidivists where they're picking up new charges.
It was like a fluke in their life.
Right.
And I think that that's really kind of the driving force a lot of times. If there's a victim, it makes it a little bit more complicated because you have to meet everybody's needs at that point, not just satisfying the state. Now you want to make sure the state and the alleged victim are satisfied with the terms of the agreement. And then your client usually is on board with it because they're wanting this as a vehicle to get to a dismissal. But when it comes to alleged victims being involved, sometimes restitution is a part of the agreement, and you have to make a payment in advance towards restitution, usually completing restitution payments in order to get that case dismissed. So there's a lot of different scenarios in which like this can present, whether it's like an alleged victim is involved or not. But I think at the end of the day, this is a really great way to ensure that you will have a second chance without having actually like a criminal record. And they have this, and you said this is for like DPAs or for lower level felonies too, but they have like the pretrial intervention agreements in, I guess, the more serious felonies, because sometimes as a part of those, you actually do get a dismissal, but they require an admission of guilt where you admit to the court, I did this.
Right. And there are different types of diversion. The deferred prosecution agreement that we're talking about is really, I would say, the lowest level of diversion, where the outcome is a dismissal. There is no admission of guilt or admitting to the facts.
No
of
risk,
anything.
really.
There's really no risk.
Yeah.
And if you don't complete the diversion, all that happens is that the prosecution just continues.
Right.
There's no downside.
Right.
There are other types of diversion, something called a plea and pass,
right,
where somebody will have to make an admission of guilt, enter a plea, and then do a program. And after they do that program, at that point, when sentencing is, the person pleads and then it is passed on to sentencing, at sentencing, the state attorney's office could then say, okay, they've completed the terms of this agreement. I'm going to do one of two things. I'm going to either give them a reduced charge at the end now with some sort of, reduction in terms of the actual sentence, or we're going to agree that they can rescind the plea that they've entered. That plea paperwork will be destroyed, and then we will dismiss the case. The reason that prosecutors sometimes choose to do that is because this is almost like a DPA with teeth. Because at the end, the prosecutors have something that they can fall back on and say, okay, if you didn't complete the terms, it doesn't just go back to the regular prosecution. Now you're locked in to whatever that agreement was. So you can plead to a charge, the sentencing gets passed, and then either you have a dismissal, or if you didn't complete that program, then the state can say, okay, well, now we are either convicting you or we're withholding the conviction, and there are going to be an additional set of terms because you failed to meet the agreement that we had made. And that's one type of one type of diversion.
Plea and passes can actually be used for people who have criminal history and it's oftentimes I see it as a middle ground. Sometimes I see it as a trap because I'm like, I know my client's not going to be able to get their license in 30 days. You know what I mean? Right. There's just so many things that they have to do before then or something like that. But sometimes it's a good middle ground because the state will sometimes be just gung-ho on jail or something. Like they're like, no, this person has been in trouble X amount of times for the same thing. And, I'm not dealing with it again. Like they're kind of fed up with this person.
Right.
And when you're pleading for your client to get a different alternative and they have not the best evidence against them, you can propose a plea and pass and say, well, what if they do X, Y, and Z? And in order to earn this sentence that you believe that they don't, they're
deserve.
they don't deserve. So like they work for it. And it's kind of, it usually makes the state satisfied because the downside would then be the jail that they wanted or more.
Right. They can make the downside something bad if they don't complete the condition,
so
and then they're locked in.
Yeah. So the upside isn't always a dismissal. Sometimes it could be probation.
Right. The upside can be a withhold of adjudication
or in court
versus
costs
an
or
adjudication,
right.
meaning the conviction is withheld from someone's record or they're convicted. And that's something very important that we're going to discuss a little bit more in this episode, because we're going to talk a little bit about expungements and sealing. And there is a very big difference between an adjudication, meaning a conviction, and a withheld adjudication where someone is not specifically convicted.
Yeah, it definitely changes the result of your criminal record. And so like that's the reason why diversions are often favored, especially when somebody doesn't want to take that risk and go to trial, or maybe the evidence is actually really bad. Sometimes I get actually oftentimes when somebody has no criminal history and the evidence is not good, the state is still willing to extend a deferred prosecution agreement where you can get your case dismissed. And oftentimes those are kind of no-brainers, you know, and that was a situation where, you know, we talked about my first trial and that was the offer on the table, was a deferred prosecution agreement without any conditions. It was a signature that was required and the case would get dismissed. And she went to trial. She wanted to weigh the risk of trial and, you know, thought that she could get an acquittal, which is probably the best thing you can get is an acquittal. And the next best thing is a signed DPA with no conditions.
Yeah. And I candidly think that the only times I've seen as a prosecutor, the only times I've seen a deferred prosecution agreement rejected is by a public defender. And I've never seen a private attorney turn down a deferred prosecution agreement. And the reason that I believe that exists is because I think public defenders are more willing to fight the cases.
Yeah.
And they're really looking for, you know, some public defenders, there are true believers and they're really looking to say, you know, my client is innocent and there's no way they're doing anything at all. The other reason is certain times public defenders don't have the client control to be able to tell somebody that they need to put their ego aside and accept this result. Because I have clients that'll call me and say, look, I absolutely did nothing wrong. And ultimately what I tell them is, do you want the case to be dismissed? Yes. Do you want to risk putting that case in front of a jury that may, regardless of what you're telling me, they may still find you guilty? No, I don't think that's the best idea. So if you complete a 4-hour course and pay $100 to the clerk, now we have a piece of paper that officially dismisses the charges without ever having to put the risk in a jury's hands. We put all that risk in your hands and you can control your own destiny. And if we can do that and get a dismissal, that's a win.
Yeah.
And then ultimately we can move on from there and say, okay, well, now that the case is dismissed, what do we do from there?
Right.
And before,
I was just going to say this oftentimes comes up in conversation. Well, before I go to client consults, I wanted to comment on what you were just saying with client control, because that is true. And, you know, in my situation, I don't know if that was a client control issue or because her co-defendant had actually gone to trial and it got acquitted on a bench trial. So, and that I think was just maybe an extension of grace from the court. I don't know. But, you know, at the end of the day, it doesn't really matter. I think that experience also comes into play here because I was a brand new lawyer. Like this was my very first jury trial and I was barred for 2 months, you know, 3 months. But this client had spoken to probably every supervisor in our office. So that's why I'm saying I don't know if it was a client control issue, but I do agree with those two things because also at the end of the day, you know, when it comes to private practice, there are fees associated with trial. So when it comes to clients making a decision, obviously we're not telling them, this is something they know up front when they take you on as their lawyer. Like, this is what we can, you know, we charge for X amount for the case, and this is it includes a workup for trial, but for me to actually go to trial is an extra fee. And so I don't find that usually like that extra fee is the reason why the client rejects.
That's not usually the
deterrent. Yeah, but I think it's probably an added on like, okay, well, this is a guaranteed result for me. And, you know, I don't have to pay an extra X amount for trial. And instead I can put that money towards whatever I need to do in order to get the case dismissed. And they end up going that route because it's just the safer route.
Right.
When you pose it to them, you know, in that way. And I think that it's so important because you have to explain the risks and benefits of accepting anything from the state and going to trial. And when they deny or reject anything from the state, they are effectively saying, I am going to trial. And so they need to know everything that comes with that. And so when you say, you know, that the destiny is in your hands, it really is. You know, sometimes also a condition of it is that you can't get arrested. You can't get a new charge. And that's where people...
of all of these diversion things, one of the things that would disqualify you or make it so you can't finish the diversion and get the benefit of whatever the diversion is if you are arrested again. If you're charged with a new crime, you are knocked out of diversion.
Yeah. And those are really the places I think where some people just can't help themselves. I'm just like, oh my God, like.
Yeah. And that really brings me to my next point. A couple of other types of diversion that are out there that are commonly heard. We have mental health court, which is specifically designed for people that are challenging whether or not they're competent to stand trial for the most part. We have drug court, which for people that have felony offenses that are drug related, one of the ways that, and they don't have significant criminal histories, one of the things that they can do is be put in a court that focuses on and understands that there's someone that has a drug problem, and that's what the root of the criminal, that's really why they did whatever they did, is something having to do with their specific drug problem. And drug court focuses on getting them help and keeping an eye really on them. And what I mean by that is drug tests and different things like that to make sure that they can get through that program and then have the charges either reduced or dismissed at the end.
The only thing I would probably disagree with you on is the mental health thing. Like, I don't think that's a diversion. I think that's just like a different court for.
I think that when I say diversion in that respect, I literally mean it's being diverted away from the regular court proceedings.
Okay.
And instead of going through the normal prosecution in front of a circuit court judge, that's a trial division. The case is taken out of that division and put somewhere else. So it's literally diverted. Same thing with Veterans Court.
Yeah.
It's not that the Veterans Court, for Veterans Court, if you qualify and you are, again, depending on your criminal history, depending on what the charge is, they can put you in a court that's all related to
the needs of a veteran
and intertwined with Veterans Affairs and making sure that, a person is able to get the actual help they need while getting rid of this criminal case.
Yeah.
And while still being monitored in relation to the criminal case, but they're able to get access to different resources. And, in a standard diversion, if somebody tests positive for drugs, that knocks you out of diversion. In a drug court diversion, that may not necessarily knock you out because there's an understanding that this person has a drug problem and that relapsing is not always a sign of them just going against whatever the diversion is. They may just have that problem and things happen for people that are addicts. That's just the way that it is.
Seen that.
I've seen that before where somebody tests positive and then they're not necessarily knocked out.
Nice.
But I mean, that's not always the case. If you pick up a new drug charge, that doesn't mean that you're not getting knocked out. Yeah. But that, again, is just another type of diversion.
But just since we're talking about mental health, so people know what competency is, like as a side note, it's not what we're talking about necessarily today.
Sure.
But competency is usually raised by defense counsel, can be raised by the judge or the state as well. But it's when the attorney has concerns that their client doesn't understand the actual proceedings and, the risks and benefits of the plea that's being offered or going to trial or why they're even
they are not able to help or aid their defense or speak with their defense attorney clearly.
They can't understand the gravity of their charges. They can't understand the seriousness of what's going on. So usually it's mental health related. Once that's raised, a doctor gets involved, there's evaluations, and then it gets diverted into mental health court where all of that is litigated between the state and the defense. Sometimes state agrees, and then they put them in the hospital, and then the person gets their needs met. And then if their mental health is restored, then they go back into court and everything's back to normal. But that's what competency is in a nutshell, basically. And
we could do an entire episode, and we probably will at some point do an episode on mental health and mental health court because it is oftentimes it's a complete disaster.
It's so bad.
And I say that because there are different evaluations that are done. There are arguments about the evaluations that go back and forth. Getting a client that has significant mental health issues to even be evaluated can be a challenge.
So hard.
And then ultimately, once a person is found to be not competent, if the best decision moving forward is to put them into some sort of hospital, the process of getting them into that hospital, waiting for a bed to open, the potential of them having to sit in jail waiting for a bed to open is a nightmare. And I've gone through it multiple times with multiple clients, and it's never a smooth process. No. But that's not what we're talking about today. We're more so talking about the diversion that we deal with. Yeah, right. So sorry, I didn't mean to cut you off, but we were also talking about drug court, which is a real, diversion court where you sign an agreement with the state and that's hopefully to get your case dismissed. And then we have, I don't think we have any other. We talked about, there's mental health court, veterans court, drug court. Those are really the three. Plea and pass, PTIs, and DPAs. Now, the next one that I want to talk about for diversion that comes up a lot for, certainly for me in my practice, and I know for you it comes up, is in the DUI perspective. Yeah. So in Palm Beach County, we are lucky enough, and I say we are lucky enough to have the diversion program for DUIs because that doesn't exist in every county. The DUI diversion program is where someone is charged with a DUI, but the state attorney's office is willing to reduce that charge to a reckless driving and have the person partake in a program that is similar, almost identical to what they would have to do if they were convicted of a DUI and went on probation. So instead of having all of the ramifications that come with a DUI, they would get a reckless driving. They would not get an additional license suspension. They would not have some of the other collateral issues that come along with that, like the raised insurance. There's different conditions that they may have to complete as part of the reckless driving program versus what they would have to do under statute by being convicted of a DUI. And it's a huge benefit. And it's designed for people that have never had a DUI before or a felony conviction before, that have never had a diversion like this before, that if they gave a breath sample, the breath sample has got to be under a 0.2, or they can, if they refused, that doesn't disqualify you from necessarily being in it unless you have a prior refusal, then that would disqualify you. But once you're offered that program, the reckless driving that you are offered comes with a withhold of adjudication, meaning no conviction on your record. And what that means is if the only thing that you were ever dealing with was a DUI that was reduced to a reckless driving and you went on the diversion program, you completed 12 months of probation, you received a withhold of adjudication, meaning no conviction, then you can get this removed from your record. Okay. There's one big problem that has started to arise specifically in Palm Beach County on this issue. I don't know if you've had to deal with this a bunch, but I've had to deal with this a few times now. Because you're dealing with diversion and because we're dealing with a plea, ultimately the judge has to accept the plea and has to accept the terms of the plea. Judges, at least two that I know of in Palm Beach County, will not accept withhold of adjudication on reckless drivings where they were originally a DUI. There's two judges that will require a conviction on the reckless driving. And what that does is ultimately prevents the person from being able to get it taken off their record at the end of the day. Yeah. And that's a very big deal. Now, I understand there's the argument from these two judges is basically that they don't want the idea of somebody who had a DUI getting it completely taken off their record, and so nobody could ever see that happened. I understand that that's kind of where they're coming from. I don't agree with it at all. I think that if the agreement is between the state and the defense and the program is there, and it is not like they're just getting a slap on the wrist. Yeah. They still have a year of probation, drug testing, DUI school, ignition interlock device in their car, community service, a victim impact panel, fines. They still have to do all of those things. License suspension. Well, not on the reckless driving, right. But on a DUI, you would have a license suspension. That's one of the benefits of getting the reckless driving is no additional license suspension. for the judge to then intervene at the last second and say, no, we're not going to do a withhold of adjudication. It's really unfortunate, and it sucks because I'll have clients in multiple courtrooms, all with diversion deals, and we're getting different outcomes. And that's not really the way it should be. When
they've rejected it, have they said that that was the reason why?
No, they'll just say that they won't accept it they will not accept the plea without an adjudication. Based on their review, which means they've looked at the probable cause affidavit, they're not accepting the plea terms as is.
That's so
and it's
annoying.
Only 2 judges that I've encountered that do this, but they are doing it every time they're presented with these pleas. So it's at least across the board, but it's really, really unfortunate because these programs were designed to give somebody a bit of a break.
Yeah, because the DUI statute, the sentencing statute for DUI requires mandatory conviction. Doesn't matter if it's your first time, your third time, your fourth time, every single time you are charged with a DUI and you plead to a DUI, you have to be convicted. There is no withholds on DUI. So that's also another thing. So it's like they're literally doing this agreement to avoid that.
That's part of the whole part of the diversion program. One of them is to avoid a conviction, and the judges are interjecting and taking that away. And it's unfair, but that's because ultimately when you're dealing with a plea, a judge has to accept it. There's no way around it.
Yeah.
There's no way to get into a different courtroom to try to avoid that. There's no,
that's your judge.
That's your judge. And, unless there are a group of defense attorneys that come up with some creative way to try to challenge that, which there always are. There's usually, when I'm in the courthouse and there are other lawyers that are complaining about this specific situation, there's usually a few guys that work at, like ticket heavy, traffic ticket based firms that are really willing to challenge this somehow.
Yeah.
And good luck to them. I don't know how they're going to do it, but
listen,
it's unfair and it's we're definitely on board. But it's unfair and it's unfortunate because the clients lose the benefit of the bargain.
Yeah.
I represented a lawyer who I got the diversion program, and for professional reasons, she wanted to do everything she could to avoid a conviction. And the day that we went into the hearing for the plea, the judge said no. And there's nothing that I can do at that point other than look at my client and say, look, it's still in your best. It's still better than the DUI. It's still in your best interest to do this. But now it's something that we can't take off your record at the end of the day.
Yeah.
And that's shitty.
Yeah, but thankfully the Florida bar will probably still let her practice law because
the Florida bar is still letting her practice
if she
law.
Reported it and did everything she's supposed to do, because watch the ethics episode to learn more about that. But there is another diversion program in Palm Beach County, which I remembered while you were talking, is FTOPS, which is first time offender programs in domestic violence courtroom.
Okay.
And this comes up. So in domestic violence courtroom, they have their arraignments scheduled on specific days of the week, and it's set up kind of differently than the other courtrooms in Palm Beach County for misdemeanors. But the reason why I mentioned that is because arraignments is when they announce if they're filing charges and all those things. You have your first appearance, which is 24 to 48 hours after your arrest. That's when you see the judge. They set a bond, and then they give you your court date for your arraignment, which is a couple weeks away, and that's when they let you know we're dismissing or we're going forward. And so it's in that time period that the state will extend a first-time offender program, and that is a diversion where they say, hey, you have the opportunity to get your case no-filed, which is a pre-filing dismissal, meaning we will choose not to file charges against you if you successfully complete the terms of this agreement. And usually they're shorter in time frame than like the deferred prosecution agreements, the plea passes, the pretrial intervention agreement, because you're basically under the time limit of the government having to file charges. So that is also, a benefit is that you don't even get to the point where, on your record, it shows that you had charges filed against you. Like, I don't even think obviously, if you want to expunge an FTOP, you can. But I don't even see it as being something very necessary to do.
The arrest is still there.
Yeah, the arrest is there.
So you still have a domestic violence arrest on your record if you don't expunge it.
Exactly. So depending on your career and things like that, obviously it would matter. But it shows that it was dismissed.
Right.
So that's also a really great thing. So that's, another opportunity to get your case dismissed before the state ever brings charges. And oftentimes I find that when those are rejected, the state files charges and then they offer a DPA. And it's like, why didn't you just take the FTOP?
Right. And I mean, in domestic violence, the programs that they usually require people to participate in are like 9 months long. I mean, the batterers intervention program is like a 9-month program.
It's like 26 weeks.
Yeah.
And it's very expensive.
Right. So they're, a typical diversion agreement somewhere else, a DPA in another courtroom could last 30 days. Yeah. Sometimes it could last less if you complete all the conditions. It could be the same day.
Yeah,
if it's
literally.
just to go downstairs and pay the cost of prosecution, it could be like same day. Yeah. So, the domestic diversion programs take a significant amount of time.
Yeah. And, what's really important is having the attorney, when you have like consults in general with your lawyer or with the lawyer that you choose to hire, I think these types of agreements should be discussed in your first time talking. I think that you need to be able to screen the case and your client pretty quickly to be able to see, especially if it's like a lower level case, like a misdemeanor, a lower level felony, where you can be like, okay, I think this is something I can get you. I think I can help you get this case dismissed, and this is the way I think we can do it. And like, what do you think? If that's something that, they're interested in and they're like, yes, that's something and then you're like, okay, this is how I plan to do it. And that's usually when I'm like, my clients close the deal with me, because it's like, okay, we already have a strategy set up as I'm telling them, what they're facing. I'm educating them while also letting them know this is how it take the case on if you don't want to go to trial. If you want to go to trial, we get the evidence and there's triable issue, I will tell you, we have a case, let's go to trial. We had that with our case recently. So he didn't have a diversion on the table. He should have, but that would have never happened.
Well, they dismissed it outright. That's even better.
Yeah, exactly. That was
that's
cool.
You raise a really good point. I think that a lot of people that come in initially for consults are feeling a certain type of way about their case and feel, they did nothing wrong, they're innocent, and you're automatically realizing, okay, this is, the severity of the case is pretty low, they have no criminal record, they otherwise would probably qualify for some form of diversion. I want to broach that subject with them. That's a delicate conversation to have, because this person who's telling you, I absolutely did nothing wrong, you're saying, understanding that you did nothing wrong, there may be a program that you need to complete and this will all go away. And it's almost telling them, look, I get that you did nothing wrong. Well, if you get that I did nothing wrong, then why should I need to complete a program? Because ultimately, whatever we can do to get to the dismissal, that's the name of the game. So even if you have to do something, even if you're innocent, but you have to complete some sort of course or something to that effect because we know it's going to get a dismissal, that's worth everything.
Yeah.
And that's where the experience of the lawyer is so important, because you have to explain to your client, look, putting the ego aside, putting aside the fact that you may be completely innocent, and I'm sitting here hearing you and I agree with you, there still may be something that you need to do to resolve this case. And if you can get them on board with that from an early perspective and get them to understand that the way that you quote unquote win is by getting that dismissal, that's huge. That's everything. And that does set you up that helps you explaining the expectations for the client. And it also puts you in a position where it's like, okay, I know that once I get this deal in place that I'm pretty sure I can get, my client's going to be on board.
I feel like the case resolves so much quicker.
It does. And it's smoother.
Yes, it's smoother. Your client also usually gets started on things that will be needed. Depends. you can't get started on restitution until you actually have the agreement.
Right, but if it's a theft, let's say it's a petty theft case, they can get started on
the theft course. Yeah,
right.
And you usually, even if they haven't signed anything, if you present that to the state, you could probably just pay the COP and get the case dismissed the next court date. Like, there are so many ways you can just have like your case dismissed so quickly if you're receptive or open to hearing or having a conversation about that during your consult. And I find that whenever I do get, those cases where I'm able to identify that this person will likely have a DPA, on their case. Obviously, I explain that this is not something on the table yet. This is something we may have to, work for. Sometimes I have to file legal motions just to get the offer I want to get. And that offer sometimes is a deferred prosecution agreement, because there are sometimes people who get arrested and their offer. I have a client right now. I am doing everything in my power. A stand your ground motion is coming. We are working on that, but just to get a DPA, like same exact thing. Like, she has no criminal history. She has a probation offer. She's like 55 years old. She should not be on probation. She's never been in trouble before. This was like a random fight that like nobody wanted to be involved in. And like, it's just like such a waste of time. There's like 3 co-defendants. It's a misdemeanor case, and it's turning into this like huge thing where like nobody's ever going to speak to each other again, like in terms of the people involved. And it's like, there's really no reason to continue dragging it out. But obviously Marcy's Law in Florida kind of just tanks some cases. But in this situation, I intend on filing, hopefully when this airs, it'll be gone.
Yeah, by the time the episode airs, hopefully the case will be dismissed.
Exactly.
Yeah.
But sometimes we just got to do certain things to get the DPA we want to get on the table. And that's a part of the conversation too.
And like we said, the ultimate goal here with the majority of the diversion programs is to get either the dismissal outright or get a withhold of adjudication.
Yeah.
And the reason that those are so important is because of what happens after the case. The case is over, the case has been dismissed, or you have a withhold of adjudication, and you have a client that has no criminal history. The next inevitable question is, what do we do about the criminal record, and how do we get this removed? That is the process of either expungement or sealing.
It's really important to know that, though, before like you take the plea.
Well, yeah,
of course. To discuss that at least with your lawyer, because if my clients don't bring up expungement or seal to me, like, I'm doing what's in their best interest and overall. Like, sometimes that means taking a conviction to avoid jail time. You know what I mean?
Right.
So, like, those things need to be a part of the conversation.
Right. But with a scenario like that, if you have a conviction, that disqualifies you from expungement or sealing.
Exactly.
In Florida, you're only able to expunge or seal a case one time. It has to be a dismissal for it to be an expungement. So that means either the state enters a no file where they choose not to file any charges, or they enter a null pros where they dismiss the charges, and stop the prosecution. In those 2 scenarios only, you can get a case expunged after, as long as the charge otherwise qualifies. Most charges that we handle do qualify. There are certain dangerous, more violent felonies or domestic charges that don't qualify for expungement or diversion, and that's right in the statute on expungement or diversion. Those charges are enumerated. But otherwise, if you just have somebody, it's a first time, they can start the process after the case is dismissed of trying to get the case expunged. If the adjudication was withheld, or if they go to trial and they are acquitted at trial, the option exists to seal the case, which a lot of people think is ridiculous, and I am one of those people. If you go to trial and win, I think you should be able to expunge the case from your record. That's not the way the law is. If you win at trial and you are acquitted, the only thing that you can do in Florida, if you have no other criminal record, is get it sealed.
Honestly, I think it should be automatically expunged. I don't think it should count towards your once-in-a-lifetime chance to, like, you were charged by the state or the government for X, Y, and Z. They could not fulfill their obligation. Why should you have to have that on your record? I think it's cool to have a not guilty on your record, honestly. But
and then
if that person,
still somebody has to look that
exactly.
If somebody looks up your record, see, that's the thing. When somebody goes and is a person that's outside of the criminal law world and they look up the record, if it's even just an arrest and it's not, even if the case ended in a dismissal, if the arrest is still there, people are going to look and have ideas about what it was. They're going to see what the charge was, and they're going to go, oh my God, this person was arrested for domestic violence, forgetting about what the next part of the docket says, that they were acquitted or it was dismissed or whatever. They're going to see that. So it's so important for people, especially professionals, to get these cases removed from their record.
Yeah.
So setting up different impediments to doing that, or having a judge get involved, and the judge is the one that at the last second says, no, I'm not letting you take a withhold of adjudication on a reckless driving. You have to take an adjudication. Now that conviction on your record prevents you from getting it taken off.
That's so wrong.
And it is showing that you were arrested for a DUI. So somebody that doesn't know any better is going to open up the case, see DUI, see the arrest, and go, oh, this is what they were charged with. This is probably what they pled to. They have a DUI on the record, which is not the case at all at that point.
Yeah.
That's why it gets so frustrating when the judges will intervene on their own and make the decision that they're not, happy with a withhold of adjudication on a reckless driving.
It should be, honestly, if you want to reject it, fine, but at least they should say on the record why they're rejecting it, and they should also be making it not like a cookie cutter thing, like, oh, all DUIs and reduced down recklesses are rejected. Like,
well,
it should
and they're
be
not
for
supposed to
a
have
reason.
policies like that.
Yeah,
that's not really legal for them for judges to do.
That shows that you have a bias.
Correct. That's why. And
you're not a fair person.
Reason. Correct.
You should not be on the bench. I don't know who these judges are.
Now, I'm not going to say who the two judges are.
Let's not,
because I practice in front of them.
Yes,
I'm going to be in front of one this week. I'm not saying it. So, but
anyways,
but
the difference between expunging something and sealing something is big. And
so expungement, the best way to explain it and look at it is if, and we're talking obviously in Florida, if all of the reports, videos, all of the evidence gets sent to Tallahassee and the Department of Law Enforcement destroys it, and the entire record is literally destroyed. Whereas sealing, all of the evidence, all of the records, all of the documents goes into an envelope and is literally sealed, and put into like a warehouse, Indiana Jones style. So it still exists, and technically there are ways to file motions to try to reopen and unseal a case. But with an expungement, it's completely destroyed.
Yeah.
However, the question that we get all the time is, okay, my case was expunged. Is it really gone?
Yeah. The
answer is yes and no. On all of the government websites, so the clerk, the booking blotter, through the police agency, however you would ordinarily
any
look it
formal
up,
background check too would reflect this too.
It's gone. But if a private company like a news station decides to post a story about your arrest and post your mugshot, all that stuff stays.
Yeah.
If there's a Facebook group that, tracks people that get arrested for certain things, that doesn't get taken down by virtue of a sealing or an expungement.
The way this naturally happens is that once you get arrested, your photo goes on the blotter, and the blotter is public records. The clerk site is public records. And really anybody who knows how to use these websites can get access to these things. And oftentimes it's like, there's Palm Beach mugshots. I follow them.
Yes, so do I.
And like all these other, websites or like accounts where these people wait for the blotter to show up, they copy and paste and they save that information. Later, this information is destroyed by way of expungement or sealing, or, sealing is actually sealed. And then, these people are seeing their photos all over the internet and they're like, how is this happening? Why is it still there? And you're like, well, these are private companies and this order says for the government to destroy it. So you have to take it up with these private companies now.
Right.
And so there are other companies, these third-party companies that will help you clean up your reputation basically on the internet and help pay these companies. Try. Yeah.
Because that's the problem, that none of these companies none of these companies that are out there, these third-party, reputation defender type of people that can actually fix everything and get it all away. They can contact these, news sites or Facebook groups or other things and say, hey, this person has a lawful order to take this stuff down. Please take it down. But it's a please take it down. It's not you have to take this down, and the private parties don't have to. So if the Boca Observer newspaper posts about one of my clients getting a DUI and I get that thing, no filed, and we're able to get this expunged from their record, I get a call inevitably a few months after the case is completely expunged from a client saying, hey, you know, my mugshot's still popping up online. The police report's still popping up online. The body cam videos are still popping up online. And there's nothing that I can do at that point because I've done under the legally everything we can to get it taken down.
Right.
But that's why, you know, some of the criminal cases are never really gone, even if they're gone.
Yeah.
And they still will follow you. And
well, oftentimes these companies or whatever these news stations will require you to pay them to take it down. They'll be like, okay, we'll take it down. If you give us X, Y, and Z amount. I don't know how much they usually charge, but it's not cheap. It's not cheap to get these.
And then others will just say pound sand and they won't actually take anything down. And they'll just leave it up. And that's like, you know, there's nothing that can be done. I have multiple clients that had some, shall we say, interesting DUI videos, and
on YouTube,
those are on YouTube now. And you know, whether it's the cop that posts them or whether it's a news reporter that read the probable cause and was like, oh, I want to file a public records request and get these videos. It could be anything.
I ironically got a call yesterday, and it was like some guy saying like, is it okay that Law and Order has my video posted of my interaction with X, Y, and Z? It was like a body worn or something. And he was like, I want this down. And I'm like, I can't help you, guy. I'll send you.
Yeah, there's nothing I can send you to one of these companies that has a third party that says they can do it. And you can pay them a bunch of money and hopefully they can do something.
Good luck, Chuck.
There's no guarantee with that.
Yeah.
And that's just the way it is. So,
but overall, I think, you know, I think what's good about this episode is that if anybody knows or is exposed to somebody who has been like never been in trouble before, they're arrested for the very first time, I think it's like really important to address. And oftentimes I think people do because they come in with so much anxiety, they bring all this up, but like bringing up your needs and desires for the outcome of the case in terms of dismissal, expungement, you know, whatever way or whatever you're willing to do to get there. Those are a part of the first conversation you have with your lawyer. And I think it's super important to mention it. So, you know, I think it's really important because people don't know that diversions exist. They don't know. Like oftentimes I'm the one that's saying, well, like, you know, there's something called a diversion. They're like, what's that? I don't even say a deferred prosecution agreement because they're like, what? You know, like, I'm just like, you know, this is a way that we can literally divert your case out of being like prosecuted by the government. So it's just, you know, an option that we can try to explore if you're willing to explore it. And oftentimes when I do pose it to them in the way that we just discussed, they're willing to do it. And they usually feel relief when I mention it. So it's always a good thing to talk about. And, you know, I know we wanted to talk about it because it was something that, you know, people just don't know about. So,
yeah. I mean, how often do you get a phone call and the phone call starts off with, this is what I was arrested for. I need it taken off my record. And what people don't realize is you don't have any guarantee of getting it taken off your record, first. Second, by the time you're calling me, there is a record of it because it's usually in the clerk system. Exactly. So now it's public record. Anybody can find it. And three, if we're able to get you into a position where it gets dismissed or you get a withhold of adjudication, the process of getting it expunged or sealed is still another 6 to 9 months down the line.
That takes forever.
So this is not going away anytime soon.
Yeah.
And the goal can't just be right off the bat that it's off my record or nothing. Because just like you said, sometimes a win in a case is taking a guilty conviction, but avoiding prison or avoiding jail.
Yeah.
And that's just the way that it is sometimes. It really comes down to each case.
Yeah, exactly.
Yeah.
It's a really good wrap up. So I think that's all we got for today.
Yeah, that's it.
If you liked listening to the show, make sure you like, comment, and subscribe. We are on all platforms. Subscribe to our newsletter. We're at comebackwithawarrant.pod. Give us a 5-star review. And if you didn't like listening to us,
come back with a warrant.
You know that thing where you get an amazing pair of shoes at a really great price and want to tell everyone about it? Yeah, so do we. Here at Designer Shoe Warehouse, we'll give you something to brag about. Like the latest styles from brands you love, or the trends everyone's obsessing over, or shoes that make you feel like, well, you. So go ahead, show off a little. Find shoes that get you at prices that get your budget. Head to your DSW store or DSW.com today. DSW, let us surprise you.